We're going to officially call the program to order, and those of you may met with MACBAG may say, who's he? I'm Grant Stein. I'm an attorney with Alston & Bird, but I am here in my capacity as the counselor to the W. Homer Drake Jr. Georgia Bankruptcy American Inn of Court. And you, the MACBAG folks that are here, are nice enough to let us join you tonight. We did this last year, and we thought it was the best thing we did all year long, and we asked if we could come be your guests again, and we invited ourselves, in other words, and you said we could. Couple of things, just by way of who's here. Judge Bonifel is the president of the Inn this year. With him also is Judge Haganaw, Judge Richie Craig, Judge Bezier, Judge Deal, and Judge Massey, who is here. And it's one, I got you, Judge Haganaw, but it's good, okay. Yeah. 2 or 3 beers into it. In any event, oh, I didn't see Judge Laney get here. That's great, and welcome. And we have folks from Columbus and Macon and a few other places, from Rome also, good. And what I wanted to do just to check is I know that we have people here with Professor D'Agostino from John Marshall. Would you raise your hand? Thank you. Georgia State? Good. Oh, we got 2 Georgia State folks. Great. I need to make sure we meet. And any Emory, Georgia, or Mercer? From, wonderful that you're here. Thank you. And thanks for being with us, which is what the Inn's about. It's trying to get law students and the law clerks a chance to meet people in the bar that will help do what MACBAG has been doing for 20 years, which is talking with young lawyers about the right way to do things. And when Rich Thompson started MACBAG all those years ago, and what you all have continued to do has been wonderful. One last comment, if you want, is it was mentioned a couple of places that Judge Drake received a Distinguished Service Award from the American Inns of Court and the National Conference of Bankruptcy Judges. That award has made it back from Las Vegas. It's on the table, and anyone that wants to take a look at it can. With that, I'm going to turn this over to Alyssa Whatley. Again, thank you for having us. And Alyssa, thanks for putting this together.
Thank you so much. I just want to thank everyone for coming tonight, especially our distinguished guests, the judges. We have some trustees here and a lot of law students. For all the law students, you're always welcome to come to any MACBAG event. You can just email me. My information on the State Bar, come out to me afterwards. I'll be more than happy to put you on the server, and you can come to any of our programs. We always love having students. And I also want to give a very warm welcome and thank you to Professor Jack Williams. I'm really happy to be speaking with him. He was actually my professor at Georgia State, so this is a great honor for me to be here with him and to talk to all of you guys about taxes and willful evasion and self-settled trust and all these really fun topics that don't come up that often in bankruptcy, but that's what makes them fun and interesting, because the rare chance they do, this way you'll be able to recognize when these become an issue, especially from the debtor's side, and recognizing what that debtor looks like. Because I've had them walk into my office. I know I look really young, but I've worked about 220, settled about 220 tax cases. And I would say out of the 220 that I've had, 20 of them are clearly in this willful evasion category. So that's what we're going to start with. And I've kind of dissuaded them from filing bankruptcy because I knew that they would be a target. So I'm going to show you how to point those people out when they walk into your office. Or if they're already in bankruptcy, some things that the court will be looking at. So this flow chart has been floating around, I feel like, for a while. And the reason I put up the flow chart is because we're going to really focus on a very specific area of dischargeability exceptions. So we're going to focus, if you go over to income tax, when somebody walks into my office to file bankruptcy, Or if I'm doing a tax analysis, a lot of times I'll go over all their IRS options, and then I'll also go over bankruptcy options. But in order to give someone their bankruptcy options, you need to make sure whether their tax debt is dischargeable or not. And I know when you're in a hurry and you're trying to file someone's case, maybe you don't want to take the time to go through and do this analysis, but I have seen, not to scare anyone, I have seen cases where $100,000 of tax debt might have been dischargeable, but the attorney didn't take the time to go through these steps and make sure, right, and they just filed the case when, as Professor Jack Williams says, time is your friend. And all you needed was those account transcripts and run through that analysis real quick. So we're not going to do the whole dischargeability analysis because we're focusing on willful evasion. But if you are going to be at the Cobb County Bar CLE tomorrow, I'm going to go over ACEDs, CSEDs, transcripts, and we're going to do step-by-step dischargeability analysis. So come to that. So the first step, right, was the tax return filed? If it's not filed, it can't be discharged. Second step, was it return due including any extensions within 3 years prior to the petition date? And it's very important to see including any extensions, right? So if the client filed an extension for filing their tax return, the due date's no longer April 15th. It's now October 15th, right? So when you're factoring that into your analysis, you got to make sure and look in the transcript and see if they filed an extension, because that's going to change your timeline. Was the return late? Filed within 2 years prior to the petition date. Again, you can't, I have clients who are like, well, I haven't filed tax returns in 4 years, can I just file them right now? And then we file the bankruptcy? Well, that's a little too late then, because now we got this 2-year rule, and if you want to file today, that's not going to be dischargeable just because you didn't file on time and you didn't wait long enough. Next one is assessed within 240 days prior to the petition date, right? So when you file a return, the IRS has 3 years to audit that return once the return has been filed. So just because it was filed maybe a while ago, the IRS still has a chance to audit you and assess additional tax. Maybe if they underreported or they were denied some business exemptions or credits or anything, right? That tax they could file a return and have additional tax assessed. So each additional assessment is going to have its own statute and its own timeline. So again, back to the transcripts. It's always good to learn how to read those and know what that information is and how to find that information on transcript. Was the tax not assessed but assessable, right? If it hasn't been assessed, it can't be discharged yet. And then the most important one that we're going to talk about is, was the return fraudulently or did the debtor willfully attempt to evade the tax? So this doesn't come up that often, really with dischargeability issues, but when it does, the Department of Justice comes in very strong. You'll know because they'll file an answer and you'll see the Department of Justice on there to your adversary proceeding, and you know that they've got your client on their list. But they normally were on the IRS's list before they filed bankruptcy, and we'll talk about how they got on that list, but they're normally on their radar before then. So that's the one thing we're going to focus on tonight for my portion of the presentation. All right, so exception to discharge, fraudulent return, or willful evasion. You'll see we're going to section A1C, where that's where you find that section of the code, fraudulent return or willfully attempted in any manner to evade or defeat such tax. So we're going to talk about what the court looks for and what the IRS has to prove to actually win that claim against your client and make that tax debt non-dischargeable, and then the implications of that tax debt being non-dischargeable, because it has a very profound impact on your client's tax debt that they wouldn't have if they didn't try to get out of it through bankruptcy. So the two things that they have to prove is evasive conduct and a mental state of willfulness. All the time when I tell my clients a state of willfulness, they're like, well, I didn't do it on purpose. Yeah, but we're not talking about like very intentional. There's things that you can do, right, that are willful or considered willful, and you might not have really had that intention behind your head. And so why I put this up is the government actually has to show those two elements by a preponderance of the evidence, and these exceptions to the general rule of discharge are typically strictly construed in favor of the debtor. So the IRS does have a job to do, but we're going to go through those elements, and it's actually really easy for the IRS to do. So we're going to talk about that, why it's so easy. So what is evasive conduct? Evasive conduct is, it can be affirmative acts to avoid payments or collection through commission or culpable omission. So a lot of the times, my clients, they don't file their tax returns on time, right? They were late filing. They didn't make any estimated tax payments. They didn't make any payments with the return. So there's these behaviors that start to look like action, right, or inaction, not doing anything. And so one of the more important ones I put on here is failure to remain tax compliant. Tax compliance means filing and paying your taxes on time. And when I'm settling people's IRS debts, one of the requirements, if I get them into a deal with the IRS, is that they have to remain tax compliant. And people that aren't compliant lose their good graces with the IRS. So people that are typically on the IRS's hit list for willful evasion, they didn't just do it in 2000, right? And they didn't just do it in 2001, and they didn't just do it in 2002. I've literally watched clients owe $70,000, then $80,000, then $90,000, and now we're on the 4th year of being my client. There's $100,000. And we add all that up together, we're at $500,000. But we haven't changed anything, right? We didn't make estimated tax payments. We didn't go get an accountant. Our friend Sally's still doing our books. That's a problem. And if your client can't recognize that's a problem, then you have to help them realize why that's a problem, right? If you're not taking any steps to change your conduct, that's omission, right? You can't just be like, well, I didn't remember to do it. That's my favorite. I didn't remember, I forgot about filing those tax returns. Even though you've been my client for 4 years and you've hired a tax law firm, you paid us like $30,000 to $40,000 to defend you, you forgot about filing the returns, right? Yeah, that's going to be a tough sell for me as your attorney. And all those emails where I told you to make estimated tax payments. So this is the kind of behavior, but I put failure to ensure proper withholding. People that are targeted for willful evasion are typically not wage earners because the IRS can fix that pretty quickly with what's called a lock-in letter. I don't know if you've ever had a client like that where they're like, I don't know why the holdings are so high. If they're a wage earner, the IRS, if they see a repeated behavior of not paying enough taxes and not withholding enough tax, they'll just fix your W-4 for you. So you don't have to worry about it. But when you're self-employed, then you get the choice. That's when we start to get into this willful evasion conduct, right? Because you know your income, you know your expenses, you know what you took personally, what distributions you took. All of those things are not necessarily being reported to the IRS. I think one of my favorite comments by clients is, let's say they're an S-corp, right? And they'll say things like, well, don't they have my profit and loss on a transcript? It's like, no, that's like actually part of your job, like you take your bank statements and you get an accountant and they like calculate that for you. The IRS doesn't have your expenses. They got the income if people are reporting income to them. So what we're talking about normally is going to be a self-employed individual. They're probably going to be a little more wealthy. They're going to be pretty business savvy, or at least savvy enough to be making a lot of money to owe a lot of tax. I call it the more money, more problems effect. Yeah. So those are the kind of things we're looking for, right? Like repeated behavior. It didn't just happen one time. It keeps happening, and they're not doing anything about it. And that makes the IRS really frustrated. And so especially when I'm doing bankruptcy cases, I do try to help get them out of a cycle of owing. And even in my tax cases, the first step for me as an attorney is to get them out of this habitual cycle of owing tax. So we got to make sure that we're making deposits. We have to make sure we're paying current taxes going forward, right? So that we're not always doing this, because bankruptcy is not going to help you if you're always doing this. Okay, so what's a mental state of willfulness? Again, the bar is pretty low. Clients think it's like, oh, it's super intentional. No, it's not. It's if they had a duty to file returns and pay taxes, that they knew of that duty, and that the debtor voluntarily and intentionally violated that duty, right? So it's a known duty under the law, and you intentionally or willfully, or intentionally or voluntarily violated that duty. So in little fine print under my notes here, I wanted to put for joint returns, right, when people file married filing jointly, the IRS has to prove that against each debtor. Like, they can't impute that to each person. They have to prove it individually, right? So evasive conduct and willfulness to each person. But again, it's pretty easy to prove those things, and we're going to talk about why it's so easy. And on the other note, I put the mental state of willfulness for dischargeability is similar to the trust fund recovery penalty standard of willfulness. So I don't know how many people are familiar with what trust funds taxes are. Raise your hands if you are. Okay. Well, just in case you're not, I'm just going to talk about that real quick. So trust fund taxes are payroll taxes, typically, right? A company has 940s, 941s. They take money out of their employees' paychecks, and they're supposed to hold that money in trust and then hand it to the government. Sometimes, when businesses are getting in trouble, right, they stop paying their payroll taxes and start using that money as what they believe is a loan from their business, and the money never gets to the government. The IRS is not a fan of that, and if people continue to do that over and over and over for each quarter, every quarter they're doing it, that's known as pyramiding, and then you really get on their radar. So I had a fun little story for you. I'm going to give you an example. I had a payroll company, a large payroll company, like ADP or Paychex, not those payroll companies, and they brought in millions of dollars every quarter that they were taking from their clients to pay the clients, right? The clients hired them. They're supposed to do the payroll and the workers' comp and remit all that money to the government. Guess what they did? None of that money was turned over to the government. They spent all that money. They spent it. We went on trips. We bought really nice clothes. We never even filed payroll tax returns, 940s, 941s, for 2 years as a payroll company, right? So as an attorney, that was tough for me because I was like, well, they didn't really know, but they're in the payroll industry, so that was a straight-face argument. They didn't really know. They Googled how to be a payroll company and thought they would start one. Right? That's what my client told me. They also told me they didn't have to pay workers' comp. They were just going to self-insure it. It's like a car accident. They could just pay the claim and not actually have coverage. I act like I didn't hear that one. I was just like, no longer my client because I don't work at that firm anymore. But that's the kind of thing we're talking about, where we're taking money, we're supposed to be holding it in trust, and then we say, oh, I got to pay my power bill, or I got to pay this vendor, I got to pay this person, and I'll pay the government later, but I'm going to pay this bill first, right? And that sheer act of really, like, it's like this, right? I'm going to pay the power bill. Willfulness. Bam. Done. So that's the level of willfulness that we're talking about. Right? So that's pretty easy. It's literally, so that's why I equated the two, because I do a lot of trust fund recovery investigation defense. I'm actually flying out to California to defend a CFO and a CEO, but it's really hard. If your name is on the bank account and you choose to pay something else, right? I call it the party of one effect. The first trust fund investigation interview that I did, I've been a lawyer for like 4 months, and the tax firm that I worked for was like, okay, you're going to do that hearing. So I get to the hearing, I'm like really excited. I did all my research. I was like, I'm going to win this one. And the revenue agent was like, you know, your client's an S corp, and they're the only person in the business. And I was like, oh. And she's like, and we just have to prove responsible party and willfulness. So responsible party, you know, he's on the bank account and the signature cards and everything. And then willfulness, he directed all the payments. And I was just like, can we reschedule and can I come back another day and we can redo this? So that's why I'm trying to, it's funny, right? But it's really not funny. I think clients really understand how low that willfulness bar is, because a lot of times they do think it's something that is like an evil intent or an evil motive. And it's really just directing payments and choosing one creditor over another. So these are the prongs. We're going to talk about how the IRS could prove that against your client. So the duty to file returns and pay taxes, and debtor knew of that duty. Those are pretty easy to prove. A lot of times it's proved just by the fact that your client filed a tax return and they signed it, and then it showed a liability and they didn't send any payment. Right? Like knew of a duty. They knew they had to file because why else would they file the return and then not paying? So that's a really easy way to prove that. On top of that, the IRS is like, will send you death by letters. I don't know if any of your clients ever called you, I got a letter from the IRS. Congratulations, so is everyone else in the world. And they're normally auto-generated. And they come via certified mail, they come regular mail. They'll hit you up every kind of way of mail. And it will say you have a balance due, or we haven't gotten your tax return yet. And so we're at a willful evasion proceeding, and I remember I was actually interning for Judge Murphy the first time I saw a willful evasion proceeding, and I was at Georgia State. I was working at a bankruptcy law firm and working at a tax clinic, and I was like, this is really interesting. And you know what they did? They pulled out the letters. They're like, do you remember owing tax in 1999? And the client was like, maybe. And they're like, did you live at this address? And was this mailed to you? And they're like, yes. Okay, that prong is met. So I think clients really need to understand, like I said, how easy this can be done, because a lot of times they think it's going to be something super complex and really difficult to prove, and they kind of, got themselves in this situation. And a lot of times they think they're just going to get out really easily. So, I've seen people walk into our tax office and they'll owe $1 million in tax debt. And they're like, actually, one time it was an attorney. It was a personal injury attorney. And he was like, he read the law and he was like, I meet all the requirements. I meet the 2-year rule, the 3-year rule, 240 days assessed. I filed my tax return. It's not a substitute for return. I can discharge my taxes. And I was like, but you forgot about that last prong, the fraud and willful evasion. You've been building this up for a while. We didn't get to $1 million just 1 year, right? It took you a few years of not doing things correctly to get to that dollar amount. And he's like, well, I don't have any assets. I don't have to take the means test because it's majority non-consumer debt. And again, and my employer was like, yeah, you should just file Chapter 7, discharge it. I was like, wait a minute, guys. I think he's on the radar. And I've asked Vania, when she used to work for us, I was like, is there a dollar limit? And, she's like, I can't tell you that. Obviously, there's not a dollar limit, but you start to see, you can tell the people that are doing this when they come in. You can see it in the way they run their business. We'll get to that. But you can tell, right, because they think, I've thought it all through. I've bought a fancy house, I bought a fancy car, I didn't pay any taxes, I qualify for Chapter 7, I'm just gonna get rid of it. And that's where we come in with the not so fast, my friend. There's some other things to think about. So the third prong for willful state of mind is, it's very hard to prove that someone's intent with direct evidence. So what we normally do is we're going to look at badges of fraud. And some of those things you can see under statement of income, failure to cooperate with the IRS. If they're ignoring them, failure to cooperate is a big one. I have a lot of tax clients that will come and they'll pay me to represent them before the IRS. And then they never answer a phone call and they don't do anything I tell them to do. And then they're like, why didn't you help me? And it's like, well, we have this thing where we have to cooperate with them. We got to get you compliant. I need you to prove your financial status of your business and your personal financials, right? And they'll just ignore the IRS. So when they ignore them, the IRS is more than willing to help people, right? It's kind of like Judge Mullins was saying today. Bankruptcy is here to help the honest but unfortunate debtor. The IRS is the same way. They're willing to put someone in a payment plan. They're willing to put them in a no payment plan, right, and let their business get back on track. I put a $400,000 tax liability, a company that had $400,000 in currently non-collectible, because they were overextended, and they were on it. They were honest. It was more important for us to pay current taxes than pay old taxes, and they gave them 2 years, no payments due, right, so they could get back on track. But when you fail to cooperate, they're going to do what they're going to want. They're going to do what they want to do, which means they might levy a bank account, they might seize an asset. And so when you fail to cooperate, you start making them upset. So a lot of times, like I said, my clients will ignore the IRS. The IRS hits a bank account. I once had, I think, $90,000 drafted out of one of my clients' accounts. He ignored me, didn't do anything, didn't give me tax returns. And he was really upset. And then as soon as they have a levy hit, they're like, let's file bankruptcy so I can get my money back. You're already on their radar. As soon as you call that revenue agent and you tell them, oh, my client filed bankruptcy, can you release that levy? Do you not think that when you go to file bankruptcy that they're not going to be involved in the bankruptcy case after this person's not been compliant or failing to cooperate? They're definitely going to participate, and they're going to make sure that that client does not get away and get a free ride. And then the other one that we're going to talk about that's really important from IRS perspective and settling tax liabilities and bankruptcy would be transfers that greatly reduce assets. A lot of my clients, we're going to get there. So what does that mean, like greatly reduce assets? It means they're going out and spending all their money. They make a lot of money and they're just spending it excessively, right? We're going out and we're buying like a very large house or a large vacation home, or we're paying for our kids' private school. And all those things are really great, but when you owe the government, that's making a choice, right? It's kind of like with the payroll taxes we were talking about. If you owe the government and you choose to buy a luxury house, right, or to pay for your Mercedes over paying your taxes, right, you make that cross over the line, you pay that power bill, you pay that mortgage, you pay that kid's tuition. It's willful, right? It might not be evil intent, but it's willful, and you made a choice to spend your money. There's actually a few cases that I had that were in Northern District of Georgia, and I was helping with their tax case after bankruptcy, and I read the transcripts, right? I read every transcript, and it's really easy to prove. They just take the bank statement, and again, so the first step, you know, they're like, did you know you owe tax in 2009? The person's like, yes, I did, because you got the letter, and then, you know, you didn't do anything. And then they bring out the bank statements, which is like the most heartbreaking thing for me, because they start going line by line, right? Did you go on vacation in 2013 and spend $6,000 in Cabo? And the person's like, I don't know, I don't remember. Is this your bank statement? I really don't know. Are you the only person on this bank statement? Maybe. So that's when we start getting into a situation that I could be the best attorney in the world, but I can't get you out of that, right? And so it's really important to have these conversations. I can tell when the wealthy ones walk in, they think they're just going to like skate free from the IRS and file bankruptcy, and I got to pump the brakes and say, hey, did you do anything frivolous when you didn't pay them? Did you buy a big house? Did you buy a big car? Did you go on a vacation? I mean, you know, if it's basic necessary living expenses, they're not going to come after you. Again, we're going back to the honest and unfortunate debtor. There's a difference in paying your living expenses that are basic and necessary to your welfare as opposed to living the grand lifestyle, not paying taxes, right? And you can tell by the way the person runs their business. Maybe they don't keep very good records. One of the fun stories I was going to tell you about, which is a good example of someone, if they walked into my office and I was helping him with this tax case, and he said he wanted to file bankruptcy, I'd be like, you can't. You shouldn't. He had 7 or 8 LLCs for business. He used to develop real estate. He would buy a bunch of land and then put it in this LLC and then sell it to this developer and then build a neighborhood and then create another one. And so I was trying to help him do his finance. And he also hadn't filed taxes in 3 or 4 years. So I'm trying to help him do his financial statement for his business. And we get, you know, I said, are these entities, like what is your interest in these entities? Or do you own them outright? Are you filing as an S-corp? Are you a partnership? He was like, I don't know. I don't know what my interest is. I don't know how these businesses are formed. That's a problem. And it was even more of a problem that he didn't know that if it was an S-corp or if it was a partnership, that entity had to file its own tax return. And there's no way he could file his own personal tax return until those returns were done first, because that income flows through to him personally. A person like that, that's concerning, because he didn't file his tax returns. He doesn't know what businesses he has. Another good example, so like bad record keeping, right? Not knowing what's going on. I looked at his personal bank account for 2016, and we were trying to help him file his taxes. And that's when I sent him to an accountant, because I was like, if you don't know your interest in your businesses, you need to get a really good accountant. And they're going to have to file a return for each one of these entities and figure out what your interest is. And so I'm going through 2016, and he told, we have a basic tax preparer at my old firm that would prepare basic returns. He said, I don't know, I think I made about $150,000. So I go through just take his 2016 bank statements, I had them all up. I counted $460,000 of deposits. That's not even close to what he estimated. And then I started asking about it. I was like, well, what about this $200,000 deposit here? Oh, that's not income. That was a loan from my friend that was going to use to buy property for this LLC and put it over there. All this, like, shuffle, shuffle. That's not good. That's not someone that's being honest, right? And if that person thinks, so I'll tell you what happens. I'll ruin the punchline. He never gets me his tax returns because he gets frustrated. He doesn't want to sit down with the accountant. He doesn't want to figure it out, and he just ignores it. So at 5 o'clock on a Friday, I get a phone call. He's cursing at me in all different levels on my voicemail, and I answer it. I finally pick up, and I was like, hey, what's going on? He's like, I'm in Jamaica, and I don't have any money. They wiped out my bank account. How am I going to get home? I was like, I don't know, man. I was like, can you do me this one favor? Just real quick. And he's like, you're the worst tax attorney. I hate you. I can't believe I paid your firm. You're an idiot. You don't know what you're doing. I was like, okay, slow. Pump the brakes. Scroll, scroll, scroll. What's the last thing I said to you in the email? He said, you said that I'm missing 3 years of tax returns. I'm not in compliance. I haven't provided financials. They've already extended the deadline 3 times, and I'm subject to bank levies. Wasn't unclear about that sentence. He's like, well, I'm just saying, I'm stuck in Jamaica, and I don't know how I'm going to get home. Well, you know, he goes, why don't you just call the IRS agent? You tell them I'm stuck in Jamaica and I need my money back. I was like, oh, I didn't think about that. Let me tell them that you're on an international vacation when you owe them $100,000, and you're probably going to owe another $300,000 or $400,000. Let me just call them and tell them you're on vacation, see if they'll give you the money back so you can get home. I think that revenue agent's going to let you sit there for a little while. Because, he took his whole family. He took 15 people, paid for them all to go. When I was looking through his bank statements, he had a $1,500 cable bill. So that's what I'm talking about, right? Who has a $1,500 cable bill? That's not necessary and reasonable living expenses. So if that guy finally files his tax returns, right, and he comes back to me and says, Alyssa, can I file bankruptcy? I'm like, no, sir. Unless you have other things going on that are necessary, so that's what we're going to talk about now. Should you wait to file or file at all? So this is really more for practitioners, because we already talked about what the court looks at, what the IRS can prove. This is more for debtors' attorneys when that person shuffles into your office and they think that they've created the best, they always think that they've just figured this out, right? I don't have to take the means test. I don't have to do this. I'm going to not pay my taxes, and I'm going to have a nice house. So should you wait to file? Does the debtor have something imminent? Is tax their only problem? Because if taxes are their only problem, bankruptcy is probably not the best way to fix their problem. There's a lot of other tax resolution methods that you can learn about at the Cobb Bar CLE tomorrow. I'm going to talk about all of them. But if they got other problems, right? We got a wage garnishment, we got foreclosure, we got a repossession. We have something imminent. One time I had a big church. They owed $300,000 to Georgia Department of Revenue. Georgia Department of Revenue was like, we're going to take that church. I was like, I don't know what you're going to do with the church. But they did have a lot of equity and land. And the property tax was also trying to foreclose because they hadn't paid property tax. They had 127 liens, right? So taxes weren't their only problem. They had a lot of other problems, weren't paying other creditors. So in that case, yes, and I recommended that they file the Chapter 11. They did that. But if taxes are their only problem, they might be better off talking with the tax attorney and getting some tax help outside of bankruptcy. If we have imminent problems, then you got to pick the lesser of two evils, right? You just kind of got to move forward. And I think that's what a lot of bankruptcy attorneys do when they meet with people. Taxes are kind of a secondary issue because of some overarching immediate need for relief, right? So you have to balance those two. Maybe you could hold the foreclosure off. Maybe you could keep that creditor from coming after your client. It's kind of what I did with the property taxes in Georgia. I held them off for as long as I could, and then I was like, you probably just need to file Chapter 11. But if you know the timing of things, maybe you can hold them off long enough so something does come dischargeable if they're not willful evaders, right? If they're an honest but unfortunate debtor and you've done the tax analysis, then great, like file it, awesome. And then the second question you should ask yourself is, will filing toll a collection statute expiration date? So the IRS can only collect tax for 10 years, and then it expires. So a lot of times as a tax attorney, the first thing I do is figure out what years they owe for, and I look to see what the statute is. When is that tax going to turn into zero? A good example is I had a lady that owed $300,000, and last month, all of it expired except for $4,000. If we had filed bankruptcy, and I wasn't paying attention, right, she was having her, she's a real estate agent, so she was 1099 commission-based, which means the IRS can levy the whole check, right? Maybe it's worth them getting a couple checks because that tax is about to expire and it's no longer collectible. So that's a really important factor that you should know before you go and file bankruptcy is what is that date and when is it going to expire? But there's things that can extend it, and bankruptcy is one of those things. So a lot of times they get clients, they come out of bankruptcy, and they're like, why do I still owe this tax? You know, well, the CSED hasn't expired, it's non-dischargeable, and while you were in bankruptcy, the clock was frozen, and then we have to add 6 months plus the time you were in bankruptcy. So now, imagine a Chapter 13 client, maybe that was in there for 3 to 5 years. If they have a tax debt that's non-dischargeable and wasn't paying the 13, now you've got a 10-year statute that may like a 13 or 15-year statute. Could be very long and could really impact them. So again, if you got something imminent, go ahead and file bankruptcy. If they don't, maybe consult a tax specialist. But this is why willful evasion is important. So this is from the Internal Revenue Manual. If you look at suits to reduce assessments to judgments, oh, it's cut off. You can't see the rest of it. I'll give you the punchline. When the IRS reduces assessments to a judgment, it takes that 10-year statute and turns it into a 20-year statute from the date of the judgment. So you got someone that filed bankruptcy, you go through the willful evasion proceeding, the IRS wins, it's not dischargeable. A lot of times they'll just take everything that they did in bankruptcy court, go to district court, turn that into a judgment, and now that 10-year statute is now a new, brand new, shiny 20-year statute that person's going to owe that tax debt. So that's really important, right? When you're weighing pros and cons about filing bankruptcy, not filing bankruptcy, are they a willful evader? Definitely something to consider because then you can, I mean, I've had clients that owe tax from 1999, 2000, 2001, 2002. They still owe it because the Department of Justice did, they tried to get out of it in bankruptcy. It wasn't dischargeable. They took it and turned it into a judgment. Now it's good for 20 years. So I put a little example on here why it matters. Why does this matter? Who cares? As a debtor's attorney, you probably should care because, like I said, there's been malpractice suits just because they weren't paying attention and checking statutes and whether or not the debt's dischargeable. But here's a good example. So I had a client that owed $800,000. I had to, in order to set up a payment plan with the IRS, we're doing the same analysis that we're doing in bankruptcy, right? Income minus necessary living expenses plus equity and assets, right? We're looking at all of that same information. And they determined that he had disposable income of $1,600 a month. He only had four years left on his statute. So I put him in a $1,600 payment plan. As long as he makes every payment and he doesn't default it and he stays compliant, meaning filing and paying taxes on time. If he defaults it, then we're back to square one. But he could end up paying $76,800 on an $800,000 tax debt. Right? That's a really good outcome, even though he told me I didn't do a good job. Because he was not happy. He's like, I thought it was going to go to zero. And I was like, he actually made me cry. That was like when I was a baby lawyer, like maybe the first week of working at this law firm, I got this guy this deal. He was yelling at me, and I called my dad. My dad was like, well, you know, he's probably just upset. You should just tell him this is a tax law firm, not a Make-A-Wish Foundation. I was like, thank you, Dad. Next time when someone's yelling at me, I'll definitely tell them that. My feelings were really hurt. He called my boss, and I was like, Alyssa's not smart. She doesn't know what she's talking about. That's a good deal, right? And that's why I put in the alternative. Let's say this person rolls in, like, I want to file Chapter 7. $800,000, you're on their radar. You didn't get there for no reason. You know, it took a lot of steps to get there, and they're not just going to let you get that discharged. So that's why I'm saying it's important, it matters. Be aware of it. You can tell, again, it's the honest but unfortunate debtor. You can tell when somebody walks in and they're trying to create a scheme to get out of something, and when someone walks in and their business is actually struggling. So that's what I just wanted to present, that information, so you could be clear, you can recognize that, and you can explain to your clients when they roll in and try to tell you things that you already know. You can set them down and say, slow down. This is what they have to prove. This is how they prove it. Have you done any of those things? And that way you're protecting yourself and you're protecting your client and you're getting them the best possible result. So now I'm going to turn it over to Professor Jack Williams, and he's going to talk about other schemes that debtors use.
Thank you, Alyssa. I wanted to say you did a wonderful job. Those of you who know me, yes, please. I'm very proud of all of my students, especially those that continue into bankruptcy, and those who focus not only on bankruptcy, but bankruptcy and tax, which are two great loves from an academic and professional perspective of mine. That's something just wonderful to see. Of course, as you know, I'm impassioned about bankruptcy and impassioned about tax, and absolutely love the interrelationship between the two. And if you know my students, they will tell you that's a commentary on my social life. But aside from that fact, it's a wonderful opportunity to hear Alyssa speak about that. It's an important part of our practice, whether we're dealing with individuals, human beings who are up against the federal or state taxing authority, or we're dealing with corporate entities or pass-through entities where we're focusing on not only income tax, but payroll taxes, sales tax, gross receipts tax, property taxes, things of that nature. So it's really an important area, and I really appreciate you're sharing some of your thoughts with us. Today what I'm going to do is speak about asset protection. I'm a blocking and tackling type of person. I like to get to the fundamentals of things, because if you've got a pretty good understanding of the fundamentals, a lot of the complexity of the sophisticated device or transaction that you're looking at, or the argument that somebody's trying to push your way, oftentimes down your throat, really starts to melt. You start to see the complexity just dissolve. Instead, you see what really is at play. So one of the things I want to disabuse us of is thinking, when we look at these devices up here, of these things just as a trust, because a trust really captures a lot of different things that are going on at the same time. And the way to create these protections or to challenge these protections oftentimes is recognizing what actually is going on here when we talk about a trust, for example, in this context. And this context could include a foreign trust, a domestic trust, or the challenge of that trust under foreign or domestic law or under bankruptcy law. For example, in the 2005 amendments, we included a new reach-back provision under 548. That's the fraudulent transfer provision under Title 11, the Bankruptcy Code. And now we can go back 10 years when we're dealing with certain types of trusts or similar devices. And it's not limited to the trust. It says, or similar devices. And it's not limited to individuals. So there are a number of different devices that we see actually with some frequency, for example, in the context of commercial transactions that have a lot of the attributes of a trust that could fit in the context of similar device that would now give someone a 10-year reach-back period as opposed to the 2-year reach-back period that we're accustomed to, at least in the context where one could make a good argument that the debtor in creating or using that device had the actual intent to hinder, delay, or defraud its creditors. So as we walk through some of these things, I think keeping in mind what we're talking about when we're talking about trusts could be very important. Now, with that said, I thought we could also be kind of interactive. You certainly can ask me any questions as we walk through this process, and I'll be happy to answer them. So I thought it'd be only fair that I could call on you. After all, I am a professor, and that kind of comes with the card of being a professor. But I don't want to embarrass anyone by calling on them. So I, like in my class, will take a hint from you. So since it's after 7, anyone who's wearing a tie, that's a signal to me that you don't mind me calling on you, and that you'll be happy to try to answer those questions. So I thought what we might start with just a simple question. What do you think might be one of the first asset protection devices that may have been employed in at least Anglo law? I think it even probably predates the trust. What do you think? Yeah, I think I'm almost in that line, but see, the mattress doesn't work unless you include the thing that I think was probably one of the first asset protection devices. I think it was perjury. I think that was the first asset protection device. I think I didn't say it had to be a good one. I just said one of the first ones. People lied a lot about what they did with their assets. And then over time, people developed ways in which to, well, you couldn't really lie overtly. So what you would attempt to do is try to create some kind of device, right, to where you could put your assets out of your creditor's reach. Now, one of the things that was happening at about the time people were starting to think about this was the sovereign. I'm going to take you back to the time in England. The sovereign realized that people who committed treasonous acts against the sovereign shouldn't be able to keep all of the assets they developed under the laws of the sovereign. You know, if you are going to engage in these treasonous acts and you had created this great estate, your estate should be forfeited to the sovereign upon conviction of these treasonous acts. And usually that also meant execution as well. So what would happen is that upon conviction and execution, your estate would be forfeited to the sovereign. Well, people realized that, like bankruptcy, executions have this clear line of demarcation, like the petition date. Once you're dead, you're dead. But because they would identify the date by which those events would take place, like one can often identify when they're going to file their bankruptcy petition, they could start to engage in pre-execution planning, like some people engage in pre-bankruptcy planning. So they often would, before the trial and the conviction that they knew was probably going to come, either because they were engaging in treasonous acts or they knew they would be found to be engaging in treasonous acts because they happened to be in the political or philosophical party that was out of power at that time, would start to transfer through general transfers or assignments or through trusts all of their property. They would be convicted, executed and no property would be there. That atmospheric condition which I described is why the 13th statute Elizabeth was created and enacted. Our fraudulent transfer law, which we inherited, was designed to go hand in glove with the forfeiture provisions when it came to treason. And it was enacted to protect the sovereign. It wasn't designed really to protect creditors, at least private creditors, until the Twines case. And in Twines' case, that was the case with the sheep, right? The sheriff shows up to seize the sheep aren't there. But we do know that the person who purportedly owned the sheep was still benefiting from the sheep. And no one had heard it, that the sheep had been sold. And so we had all of these badges of fraud that would ultimately come out. And the court concludes that, you know what, this is an actual fraud, and the creditors could avoid, that is disregard, that's where we get the concept of avoidance, could simply avoid what otherwise was a perfectly legal transfer of legal title, right? It's not a void transfer, it's voidable. Could avoid that transfer and nonetheless levy upon those sheep. It was the first time in Anglo law that a law court implied a private right of action in the statute that created no private right of action, because this was only a right that the sovereign had to protect its right to the forfeiture of the estate assets. And from that time, we've had this elegant dance, if you will, between debtors and creditors over the consequences of various types of transfers and asset protection planning, and the avoidance or mollification, if you will, of the consequences of things like bankruptcy. So we're going to talk about asset protection planning, but from the creditor's perspective, they're also looking all the time at ways at which to ameliorate the consequences of bankruptcy. You see, for example, all sorts of agreements, either prior to a restructuring or within a restructuring, where a creditor is going to attempt to, for example, prohibit its borrower from going into bankruptcy. Used to, we tried to do that with just a blanket prohibition, but so many bankruptcy courts kept concluding that that was against public policy that they removed all the fun from that, so we can't do that anymore. So then now what we do is we try to use blocking directors or blocking partner or blocking member of the borrower LLC or limited partner, again, as an attempt to mollify what otherwise would be the consequences of a bankruptcy filing. Here, though, we're going to be looking at it from the debtor's perspective. And we're going to start with this Spendthrift trust, but unpack what we're talking about when we talk about a trust. And this is of ancient vintage. Then we're going to talk about a self-settled Spendthrift trust, which you can do in every state. It's just void in almost all states, all but 17. But you can do it in every state. We'll move on in the Foreign Asset Protection Trust, and we're going to focus on my favorite, Cook Island, because it's kind of a cool place. You could Google it if you want to, and of Google Maps, that is. It's really a cool place. But it really captures the benefits of a foreign trust. But one of the things, I'll just fast forward for you right now. If you talk about the creation of the trust, or the administration of the trust, or the corpus of the trust, I said talk about, that is punishable up to 1 year in jail. Now that really limits the disclosure and the discoverability of things like a Cook Island trust, when you think about that. So there's a lot of secrecy around that. Now, of course, that's in Cook Island. Obviously, that's not a crime here in the United States. But you'd probably have to remove Cook Island from your bucket list, unless it was the very last thing on your bucket list that you were going to try to do. And then domestic asset protection trusts. There are 17 states. Michigan's the most recent, I think, March of 2017. And there are steps being taken in Georgia. I've got a colleague my faculty that is a strong advocate of the Domestic Asset Protection Trust, which is a regime that allows self-settled trusts in most contexts. And that is, in many ways, the wave of the future. And it poses some very interesting choice of law questions and some interesting bankruptcy questions as well when we see those things develop in the bankruptcy area. Not a lot of case law on it right now, and very little case law in the context of bankruptcy and domestic asset protection trusts. So I'm going to come over here and advance this for us. Let's see. Okay, so this Spendthrift Trust. And by the way, I'm going to give you my email address. If you want the materials, I'll be happy to email them to you. It's jwilliams@gsu.edu. So just J, my initial, Williams @gsu.edu. Or you can give me your card, and I'll be happy to forward them to you. So the Spendthrift Trust is a trust agreement. It's designed to protect the beneficiary from wasteful spending, who historically and traditionally we called the spendthrift. And the concern is that that particular beneficiary would otherwise spend their particular share of the corpus or the assets that otherwise would go to that particular person. So the person who creates the trust, you can use different terms: grantor of the trust, the donor of the trust, or the settlor of the trust, wants to protect that beneficiary from the beneficiary's own tendency to overspend, imprudence in their financial affairs, and otherwise that concern that the beneficiary would rapidly exhaust their assets. That's historically and traditionally what the use of the Spendthrift Trust was all about. And so the trust is not going to allow the beneficiary to transfer things or alienate things or pledge his interest in the trust to other creditors or others. So it's protective in nature, historically protective in nature. So from that perspective, then, the creditors of the beneficiary are very limited as far as the trust is, the corpus of the trust is concerned. They can't attach it, they can't garnish it, and we see that under the Bankruptcy Code in Section 541C2, that corpus is excluded from the estate. That is, the spendthrift nature is recognized in bankruptcy because that limitation under non-bankruptcy law is specifically written, that recognition is specifically written into the Bankruptcy Code itself. Now, of course, if there is a transfer to the to the beneficiary, once that transfer has been made to the beneficiary and it's in the hands of the beneficiary, usually in the form of some income or distribution, then that is something that is generally subject to creditors' claims. But what we do when we create the Spendthrift Trust is that we make that distribution discretionary in the power of the trustee. In that situation, then, the trustee, if there are creditors' claims, will often decide not to make the distribution and allow that corpus of the trust then to build up, as opposed to see it simply be, quote, wasted through creditors' claims against the income once it has been distributed. So if you think about it, I've been talking about corpus and income and the role of the trustee. When we think about trust, you should think about it in that context. So the trust is actually an ancient transaction and device. You have the grantor, the settlor of the trust. It's the owner of the property that now is going to be the corpus of the trust. And before the transfer is made, he's the owner, right? And as part of ownership, he has control of the assets of the trust. He creates the trust, he populates the trust through a transfer or conveyance of that property to the trust, which is now recognized as a separate entity under applicable non-bankruptcy law, usually domestic law. He populates the trust through that conveyance. What he's doing is he's actually he's bifurcating legal title and equitable title. He's vesting legal title in the trustee and equitable title to a beneficiary. And traditionally that beneficiary is going to be a third party, not himself or herself, the settler. And typically the way that's going to happen is that the assets that will be used to populate the trust, we call historically the corpus, will remain, although they don't have to, but will reside in the trust. And then we'll assume that those assets that are residing in the trust are going to generate income going forward, whether it's annuity income because it's an annuity, or dividends because it's stock, or rents because it's an apartment complex, whatever that operating asset is, it's going to generate income going forward. And then a portion of that income is going to then be distributed to the beneficiary in accordance with the terms and conditions of the trust. Now, already think in terms of control of the corpus and control of the distribution of the income, legal title and equitable title. Now we can change what we're calling those various roles in the context of trust, and we will simply mirror what we do with in corporate law all the time. So now instead of corpus, it's just the operating assets of a corporation, and it's generating cash flows. That's the income I was just talking about. And the trustee has legal title very much like the board of directors, and the control vests there. And the beneficiaries are really the residual owners of the entity. And now what we're thinking about is how, when we create various devices for asset protection purposes, can we start to manipulate the various parts of that structure. So maybe we want to create a trust but not cede all control. Or maybe we want to create a trust, but I also want to be the beneficiary of that trust. So I want the benefits of being the spendthrift, but have all of the control rights of being the settler. Think about that. And that's your domestic asset protection trust in a nutshell. I'm a spendthrift, so don't trust me with my money, but I also want to control the money. Trust me with that. But I want my creditors excluded from the ability to access the money that I'm transferring to myself. In the first instance, because I can't be trusted with my money, right? It's such a circuitous argument that we're making here. But if we divorce ourselves from the historical aspects of what's going on, it's really about, do we reinvest control in the settler after we create the self-settling trust? And that's a policy decision at the end of the day that's really devoid of the historical moorings of what a self-settled trust is all about. Which leads us to the kind of the next point here. Let's hold on. There we go. So the self-settled spendthrift trust. When I was in law school, this is an oxymoron, right? You could do it, but it was void. And what you would do is simply, if you were the creditors, just simply ignore this. You would garnish. This would be a garnishment action, or you'd bring an alter ego action. You would simply disregard the trust in this kind of situation. So you would create a trust. You as the settlor would name yourself as the beneficiary of the trust, and you would retain most of the type of control rights that you would want and need to retain, including decisions like whether you want to pay income this year or retain the income, whether you might want to appoint a new trustee or subsequent trustees, or whether you might want to add additional beneficiaries or not. Investment decisions could be made by you, things of that nature. So very broad powers. The self-settled trust, though, as I mentioned, in 17 states is now recognized and is enforceable. And the only limitations in those 17 states outside of certain domestic support obligations is a fraudulent transfer action. But the fraudulent transfer action is itself modified. So to challenge this in the majority of those 17 states, I think almost all of them, you're looking at a 2-year statute of limitation as opposed to the typical 4-year statute of limitation under state law. And you're looking at a different standard of proof. Instead of the preponderance of the evidence standard, you have to show clear and convincing evidence, whether it's actual fraud or constructive fraud. And the remedy is not avoidance. The remedy is simply the payover of any property of the trust to satisfy the creditor's claim that brings the action, and only that. So the trust remains valid. It's just simply the creditor in essence, gets to disregard it up to the amount of the claim that's owed that particular creditor. Certainly. Yeah, so most of the time, the question is, does this analysis change if the trustee is a third party and the settlor and the beneficiary are the same? That's the classic way. And in fact, under the foreign version of this, we'll always do it that way. We'll always do it that way. And we'll make sure that all of the control is going to reside with the foreign person that's not within the jurisdiction of any U.S. court. So remember, the bankruptcy courts have nationwide jurisdiction, and they also have this nasty habit of remembering that they have in rem jurisdiction over property of the estate, wherever it's located. So it's not extraterritorial to them because it's all territory to them if it's property of the estate. Yes?
Is there a residency requirement in these 17 states that set this up?
So the question is there a residency requirement in the 17 states? Most states, the answer is no. But that poses a real interesting, well, I should say yes and no. The trust has to reside in one of these 17 states. But you're talking about the settler. Right. It poses really thorny conflicts of interest issues at this particular point in time. So you have people who take an aggressive position and have concluded that if either the trust or the settler is in one of the 17 states, then that should be sufficient. Others who say, yes, but real property is always different, right? Real property is so local in nature that if the real property is not within one of the 17 states, then a creditor will be able to rely on the law regarding that real property within that state. It's really unclear at this particular point in time, which, and I apologize to any of my students here, but I can't help it, it's ingrained in my DNA, would make a great article for somebody to write someday. It is a great one. So not many cases on that particular point. There are provisions in the Model Act and also in the uniform, the new Uniform Fraudulent Transfer Act, which we call, I think, Voidable Transfer Act, or, that are struggling with that issue. But anytime you have that mix, then it's subject right now to such great uncertainty, you certainly couldn't give a legal opinion on it. Did you have a question? No, I'm just around. Oh, not a problem. I get that answer a lot in my classes. Okay, so, oh, okay, sure. Yes, Frank. That is correct. Mm-hmm. Well, it's a good question, or a good point. Domestically, you're going to have certainly when we're talking about judgments, that's different than the recognition of another state's law and its application to a case that's pending, right? The judgment, you've got a problem. I mean, you've got full faith and credit preclusion there. But when we're looking at the application of another state's law, let's say Michigan's law, involving, we'll put the trust in Michigan, we'll put the settler, Michigan resident, and we'll put the property here, real property here in Georgia, right? And we'll make the creditor one here in Georgia, or we could even make it more sympathetic. Make the creditor a Michigan creditor, and the action is an action here in Georgia, right? So what would a Georgia court do when all of the parties are Michigan parties? The trust is a Michigan trust. It's a domestic asset protection trust. The 2-year limitation period is passed, but we're within a 4-year period, and the Michigan creditor is seeking to bring an action here as to we might even say a judgment that he may have had, or whatever claim. I don't know the answer to that definitively, because that's an area where we don't have. I don't think it's technically full faith and credit. I still think it's a choice of law concern. And historically, when you look at these cases, the self-settled trust, a lot of the courts have concluded that even the act itself is of public policy concern. So it's not just that in many of these states it has historically been something that's unlawful, but it's been something that has been repugnant to the court or to the law. So you're almost in that category. But there has been a sea change. It's been slow, but it is picking up. Now, with that said, as I've told you, I have a colleague, and there was talk of at least the beginnings of a bill being introduced this year. I would expect, if it hasn't been already, fairly within the next year or two, there will be movement in this state to develop domestic asset protection trusts. They're used for high income, high wealth people, professions who are at risk because of liability concerns, and we also see them used in a number of these states by people in the back nine of life who were concerned about Medicare, Medicaid issues, and want to start to engage in estate and asset protection planning vis-a-vis the government, as opposed to your traditional private creditor. Yes?
So these only exist basically in good creditors. These things are not.
Okay, so that's a great question right there. So the question is, these exist only to hinder creditors. So, and if you think about it, it depends on what you mean when you're referring to these things. If the question is referring to domestic asset protection trusts, in foreign asset protection trusts, I'm inclined to say yes. But if you're also including the traditional Spendthrift trust, then I would say no. Because the Spendthrift trust traditionally was designed to protect the spendthrift, right? That's its primary purpose. But you make a great point, because what is the primary purpose of a domestic asset protection trust? What is its primary purpose? Right? It's to protect assets from. That's right. And another way to think about that is to hinder them in their collection process, right? Wouldn't that be a fair statement? To hinder them, maybe not to defraud them. Yes?
You mentioned the Medicare, Medicaid issue. Isn't that already protected by normal trust as long as it's not self-settling?
Yes, we've seen a lot of trust use in that area, and it has been reasonably effective. This is, they hope, to be more bulletproof in that regard, because remember what we're attempting to do, what's being attempted here is to have your cake and eat it too. If you're willing to part with it and allow the cure period to run, then yes. But what we're looking for is a situation where you're not willing to part with everything, right? You still have to let that 2-year cure period run, but can you dispose of something but not all of it, so that there's some control? You think back of how we characterize what a trust is about. You have some control of it, substantial control, and not run afoul of the device being declared void, or somebody successfully disregarding it through our alter ego principles. So that's what they're looking for.
I guess there's certainly a trust element there too as well.
Yeah, no pun intended. Yeah. Yes, that's right. Yes, most definitely. Was there another question over here? Okay. Okay, the foreign asset protection trust, well, it's exotic, right, because there's that foreign element to it. And that's important to keep in mind, too, because if you're looking for the strongest form of protection, then this is the route you're going to go. But it's going to get you a lot of press. So can anyone think, let's say in the last month, of what, I won't say person, unless we think of it in the term of the Bankruptcy Code's definition of person, what entity has gotten a lot of press recently because of its use of foreign asset protection trusts to move its money offshore? Anyone know? Somebody said it? I'm sorry. Apple has done that, yeah. Who else has done that? How about a nonprofit? How about a relatively famous Southern nonprofit? In our general neck of the woods. Apple. Used to be headed by Morris Dees. Yes. It's moved over, I think it's somewhere over $75 to $100 million of money offshore in the Foreign Asset Protection Trust to protect itself against, well, we don't know yet. They're not talking about what they're doing right now. And I'm sure we have not heard the end of that particular type of transfer. A number of people who've been interviewed who do financial work for nonprofits are scratching their head. Nonprofits typically don't move their money offshore. Yeah. Well, they've got an awful lot of money. I think it's somewhere between $50 and $100 million that they've moved offshore to protect. Now, why would you move it offshore? Well, there are very good reasons. One, not some, but most foreign jurisdictions won't recognize U.S. judgments. Cook Island will not. You got to sue there. Comedy? No. It's discretionary anyway, but their discretion is no. It's so, yeah, we'll consider it, and no, it's not going to be recognized. They have a different judicial system. They make it very clear that the United States focuses on United States interests, and Cook Island focuses on the interest of what? Not the United States, the interest of Cook Island. In fact, the British Virgin Islands has made it very clear in a number of its opinions. You should do an internet search of some of the British Virgin Islands judges and read some of the opinions on arguments about comity and the recognition of U.S. judgments in the British Virgin Islands. They make it very clear that they don't care. Two hoots a lot of times comes up for some reason. That must be a BVI comment. I don't give two hoots, usually is how it starts. And then some reference to some judge somewhere in the United States. Then they'd have different laws and procedural requirements when it comes to their particular trusts. One of the things we could talk about here, for example, with Cook Island, as I pointed out, Cook Island requires that you challenge the trust within 2 years of its creation, not a subsequent population of the trust or a subsequent repopulation of the trust or transfer. So you can create the trust and populate it with a nominal corpus and then have a subsequent monster transfer, but you have to attack it 2 years from its creation. And of course, remember, Cook Island's that jurisdiction I told you about where talking about the trust is punishable up to a year in jail and a pretty substantial fine. And then if you were the creditor, the way to challenge it, I mean, you have to challenge it and prove it by the beyond a reasonable doubt standard. So pretty substantial standard to meet. So in other words, they're really serious about protecting that particular, I was going to say industry, but that would be cynical, right? That particular trust and trust environment. Well, of course, one of the things that pops up, though, is how do we challenge that? So a lot of times people are sloppy in the instruments, so they don't want to give up complete control. If control resides here in the U.S., either de jure or de facto, that may be all we need. So again, think about that trust. So the corpus is there, the people might be there, the trustee's always there. They require that. But if we have control somehow here in the U.S., then we'll find that control person and we'll bring them to that person in the judicial system that wears the black robe, and they have all these neat contempt powers. And we've been very successful in getting the people who have control that are in the U.S. to do things that they should be doing, but for the fact that they otherwise can rely on the cloak of Cook Island or the BVI or Bermuda or some of the other places, Gibraltar, some of the other places that pop up on a regular basis. All right? So these are the foreign asset protection trusts. Okay. We've talked a lot about the domestic asset protection trust, and it was a great point. You know, what is its purpose, right? And its purpose really is to override the common law rule that didn't allow a settler to create a self-settling trust. Why? Because its purpose historically would have been simply to hinder creditors, because the trust was a device where you would convey property, legal title would go to the trustee, equitable title would go to the beneficiary, and the settler would have no part of that transaction going forward. It would retain no control, no interest. It would be done. There would be a conveyance, in essence, just like O to A, you know, just like our first year property class, with O having no control, no reversionary interest, nothing of that sort. But the self-settled component of it, not the case at all. Now our settler's going to have a lot of control rights. And in fact, if you look at, just look at the Michigan statute, take for example, they have I think there are 11 or 12 specifically designated types of rights they can keep and are expected to keep, and it's perfectly fine without violating the statute, that are substantial control rights, the very types of things that you would think are the heart of ownership of an economic interest, that they can keep and nonetheless shield their creditors from the ability to challenge this. Okay. Just a couple of points I wanted to raise on the bankruptcy code, and then we'll just wrap it up here on the bankruptcy code perspective, because we've talked about fraudulent transfer law, the very limited nature of it under foreign law components. They regulate it, and it's their law, not ours. The domestic law limitations, the fraudulent transfer law, like in Michigan, for example, to use it as our example, limits fraudulent transfer law, remember, to 2 years, and heightens the standard of proof to clear and convincing evidence, as opposed to the preponderance of the evidence, but recognizes actual and constructive fraud, and it's the same body of law that we're familiar with. Federal law, we have 548 and the traditional 2-year reach back for actual and constructive fraud. We also have the 10-year reach back under 548E that we would need to scrutinize as well when we have things that look like a spendthrift trust or a device similar to that. And a domestic asset protection trust would look like that. It would meet the criteria that's listed in 548E. So what do you clearly could have a situation where something is not assailable under Michigan law, but would nonetheless be something that one could condemn under 548E. And that creates that kind of strategic use of bankruptcy from a creditor's perspective. So one might think that we could see in these 17 states maybe an increased use of involuntary cases, the involuntary commencement. We'll have to wait and see how that works out. And of course, any asset planning issue always poses the concern, if you're dealing with an individual debtor, of the denial of discharge if you're putting assets out of the reach of your creditors. So you've always got to keep in mind how far you go and whether that may result in a denial of discharge through a concealment or something of that nature. So that, to close the loop, is something we'd want to consider as well when we're looking at asset protection measures. So are there any questions? Yes, sir.
On the set law of a foreign asset protection trust, who gives up total control, and he goes to bankruptcy, and then he gets money out of the Canadian pension fund to finance the debt. What does that mean?
So it'll come from Canada. No, but you know, what happens in your particular in that particular, Canada has been cooperating with us because we have historically that was the easy fix, right? They used to move that to Canada, and yeah, that should have been a state property, but a lot of courts concluded that it was not, and that money would come back in. But we now have treaties with Canada that makes that a much easier fix than, let's say, Cook Island or Bermuda or Gibraltar. But people are doing the same sort of thing. Yes, that is still an acceptable route. Yeah, this is the problem. I mean, you hit the nail on the head. The problem is we know what's going on, right? We know what's going on. This is all of these trusts are devices that are designed so that the individual who's got or will have serious creditor problems, or will be in bankruptcy very soon, or will be in bankruptcy someday, or there's a high likelihood of bankruptcy, wants to be able to keep this property and it not go to its creditors. And we have a certain subset of property like that. It's called exempt property. But this doesn't fit into that category of exempt property. So they've created their own kind of form of de facto exemption. And we have to ask ourselves, how far are we going to let form control over substance in this area? At the end of the day, that's really the question as a matter of public policy that we're going to have to answer. How far do we allow form to control over substance? Because, folks, this isn't a question that 90% of the people who file bankruptcy have to ask, right? The people that you're going to see regularly in a bankruptcy court aren't thinking about, do I create a trust in Cook Islands? This is a group of people who are not, your typical bankruptcy filer. Yet again, this is a way in which to game the game, and it may be, and it could very well be, if it's done effectively with the right tutoring and an acceptable, from a legal perspective, the moral question aside, an acceptable way in which to game the game, notwithstanding that we know what's going on at the end of the day. The points that you've all made have been very good ones. But that's the ultimate issue, I think, at least from a policy perspective, that we have to come to grips with. But I can tell you what a great lawyer in this area has told me. At the end of the day, a foreign asset protection trust is always the way to go, because even if it can be busted, it's so difficult that it gives you a very strong negotiating hand. So he always creates them with his higher income earning or high wealth clients, because he figures at the end he will negotiate a deal, and that deal will always be a lot better than what? Nothing, because you're negotiating with their money at the end of the day, right? All right, well, thank you very much. We appreciate it. And thank you.